Back, everybody. Alex Murdaugh will face hard-hitting questions surrounding the deadly actions of his late son, Paul, as the family of Mallory Beach prepares to take him to civil court in August. 19-year-old Paul Murdaugh was driving a boat in the middle of the night while drunk and crashed into a bridge at high speed. Mallory Beach, who was also 19, was killed. Several other boat passengers were injured. According to investigators, Paul used his older brother Buster's ID earlier in the night to buy beer at Parker's Kitchen, which is a convenience store. Beach's family is suing the franchise itself and the specific cashier that rung up Paul, claiming that they, quote, knowingly sold alcohol to a minor. Parker's Corporation argues that the store clerk obeyed policy by scanning a valid ID, and everyone entered the boat at their own risk, knowing that there would be drinking. This week, the judge decided to let the Beach family and Parker's Corporation depose Alex Murdaugh in preparation for trial. No date has been set for the deposition as of Wednesday. But the Alex Murdaugh saga, it doesn't end there, because a federal grand jury returned a 22-count indictment on Wednesday stemming from the disgraced attorney's string of alleged financial crimes. According to a release from the South Carolina Attorney's Office, federal prosecutors are focusing on 3 specific financial schemes. In the first scheme, which allegedly took place between 2005 and 2012, they accused Murdaugh of routing settlement money from his clients into his own pocket. In the second scheme, between 2011 and 2021, they accused Murdaugh of conspiring with his banker, Russell Lafitte, to commit wire fraud and bank fraud against numerous personal injury clients. And in the third scheme, they accused Murdaugh of creating a bank account in 2015 for the sole purpose of funneling stolen settlement money from his clients. Murdaugh's defense team released a statement saying in part, quote, Alex has been cooperating with the United States Attorney's Office and federal agencies in their investigation of a broad range of activities. We anticipate that the charges brought today will be quickly resolved without a trial. So Terry Murdaugh is going to be in prison for the rest of his life, assuming his appeal is denied. Why are the financial crimes even being prosecuted?
Well, it's important that they be prosecuted. First of all, you want to make sure that those victims get restitution. When you are convicted, you not only go to jail, you could also have to pay money. So obviously he'll have to figure out where that money is going to come from, but it will go to those victims. So I do think that's important. I do think that's one of the reasons that the DOJ is bringing these charges. Now, the other thing is it could deter others from being so greedy as we know Murdaugh was with these financial crimes, obviously if he's convicted of it. But I do think the DOJ is also not focusing on whether or not that appeal is going to be granted, because if that appeal is won by Murdaugh, he gets out of jail. So the feds are going to come back and say, look, we're going to prosecute you right now, regardless of what happens with the appeal, because we know justice needs to be done. We know restitution has to be made to those victims.
But Brian, when it comes to the deposition in the wrongful death lawsuit, could Murdaugh refuse to testify or even plead the fifth to protect himself?
So he could refuse to testify. However, he would likely be compelled to at least show up because he's not necessarily living at home. He's in a jail cell. Yeah. So the courts would bring him there. They would force him to testify, or at least inquire for him to testify. If there is a situation where his testimony would lead to something that is incriminating, then he could plead the fifth, because the fifth stops you from testifying or stops you from self-incriminating when it comes to a criminal context. It doesn't say you can just not say whatever you want in a civil case, but the repercussions of not testifying would be contempt of court. But he's serving so many years in jail, it's almost like he's swimming in the ocean and dumping a bucket of water on him. Why does he care?
And welcome back, everybody. It is the second week of Verdict Watch out in Los Angeles in the second rape trial of former That 70s Show star Danny Masterson. And outside spectators are starting to see a pattern. The actor is charged with raping 3 women at his Hollywood Hills home in the early 2000s. All 3 women were formerly part of the Church of Scientology, which Masterson is still a member of. He was first tried on the charges last fall, but the jury could not reach a unanimous decision after 6 days of deliberations. It was later revealed that more of the jurors favored acquittal than a guilty verdict. His retrial started in April, and all 3 women testified about their alleged assaults for a second time, but with additional details. They mentioned that they were unusually groggy and had gaps in consciousness after consuming drinks made by Masterson. Masterson's attorney, Philip Cohen, argued that drugging is not part of the charges and there's no forensic evidence that was shown to prove that it happened. He also suggested to jurors that the victims' stories could be bolstered due to financial motives surrounding the case. Last Thursday, the jury asked to re-watch and reread transcripts of a 2017 interview the LAPD conducted with one of the accusers. They asked an additional question on Friday morning, but details haven't been released. They will return for a 5th day of deliberations this Thursday. Masterson faces up to 40 years in prison if convicted on all 3 counts. Well, with the pace of deliberations, prosecutors may have to try Masterson for a 3rd time if they want a conviction. And while trying someone a 3rd time is rare, it does happen. Seth Tetchell went on trial 3 separate times for the same set of murder charges. In 2012, his wife was found shot to death in bed in her rural Iowa home. Prosecutors argued that Seth was the only person with access to the murder weapon and that he killed his wife due to an affair. The defense pointed the finger at a mentally ill neighbor and accused police of rushing to blame the defendant despite a lack of physical evidence. Well, 2 years and 3 trials later, a jury convicted Seth of all charges in 2014, and he was sentenced to life in prison without parole. Now, you might be wondering, how common is it for trials to end in a jury deadlock? Well, let's break down some of those statistics. So some of the most recent studies are from the early 2000s. A 2004 study from the National Institute of Justice looked at 382 criminal trials across the United States. In cases involving just one defendant, 12% resulted in a deadlock on at least one count. In cases involving multiple defendants, that statistic rose to 27%. The National Center for State Courts conducted a study on more than 32,000 trials between 1996 and 1998. Of those trials, only 1,600 or 6% resulted in a hung jury. Brian, could, or maybe even should, prosecutors really retry Masterson a 2nd time if there's a mistrial?
So could, yes, they do have the ability to do that. Should, I would say no. And this is why I say that. Prosecutors are obligated, ethically speaking, to only present cases that they believe they can win. I don't see how they can make that argument after the first trial leaned towards an acquittal, and the second one, they got even more to come in. It's like the ump in a baseball game said, hey, I'm going to reduce the strike zone and make your bat wider, and if they still strike out after that, that being they're allowed to say the victims were drugged. They're allowed to say, talk about the Church of Scientology. Those are 2 big wins for them that are different from the second trial than the first. If they can't win after those additional help, then how ethically can they win this case? So should they? No. Could they? Yes, but hey, we're still waiting to see what happens.
So Terry, if this trial does end in another mistrial and the prosecution files charges again, what rights does Masterson exactly have here? Because it doesn't seem fair, right?
Well, you know, a lot of people think he would have the right against double jeopardy, but that does not apply here because if it's a mistrial, the case is dismissed without prejudice, meaning you can always bring it again. And as Brian said, you can charge someone again when there's a mistrial like that. But here, I think what Masterson could try to argue is if there's no evidence, is the prosecution abusing its authority? And they have a code of conduct where they're not supposed to be abusing any authority. And so, you know, I think he could also have a due process argument saying that he's been deprived of life and liberty under the 5th Amendment. So I definitely think that he has arguments. He probably won't win, but he has those arguments.
Let's see what the jury comes back with. And then we will debate once again on what should happen next if he's ultimately, there's a mistrial.